Welcome to my channel, Achino Gola the lawyer, Karibuni Sana, and today I have a special guest with me, and we're going to be talking about employment and labor matters. Our guest is called Oscar Onyango, and I hope you learn a few things about employment and labor related issues. And if you enjoy the video, like, share, and subscribe. Thank you so much, Oscar, for being here today. And before we delve into our discussion, maybe you could give us a brief introduction about yourself.
Very well. Thank you very much for inviting me to your show. I'm Oscar Onyango, as my host has said. I'm an advocate of the High Court of Kenya and the managing partner at Onyango and Kiambuthi Advocates. At Onyango and Kiambuthi Advocates, we mainly deal with employment and labor matters. So that is what we are going to be discussing today with my host.
Okay, thank you so much for your elaborate introduction. So today, as you've said, you're talking about employment and labor matters, and our first thing that we'll talk about, of course, is the legal framework. What are the certain types of laws that are used to govern employment and labor issues in Kenya?
Well, over time, we've made a lot of stride with regards to protection of employee rights in Kenya. And we have a number of laws today. And if I may begin with the Constitution being the principal law, under Article 41,
Yes.
that protects and actually it gives the guideline
Yeah.
on how disputes relating to employment should be handled.
Yeah.
We have the Employment Act of 2007.
Yeah.
We have the Labor Institutions Act.
Yeah.
We have the Labor Relations Act.
Yeah.
And of course, we have the Employment and Labor Relations Court Act, which is actually the principal act that establishes the employment and labor relations. And before I forget, we also have the Employment and Labor Relations Codes rules of 2016 that were created by the Section 27 of the Employment Act.
Yeah.
So that's a rough idea, or a rough terrain of our employment laws in Kenya.
Yeah, for sure, because they each cover these different dimensions and aspects relating to employment and labor issues in Kenya, right?
Very well.
Yeah, and also now, as we now go to the system of the court, which is now the principal court, actually is the Employment and Labor Relations Court, which has an equal status as the High Court. So now we want to discuss about employment and labor relations matters in courts. How are they instituted? And now the recent gazettement, I think it was in
2018.
Yes, about now chief magistrates can listen to employment and labor relation matters. So what are your comments on that? Yeah.
Very well. Lodging a claim in the Employment and Labor Relations Court has become very easy. And the understanding is that employees are standing at a weaker position. And that is the reason why the Employment and Labor Relations Court has come as a relief, actually, to most employees. The Labor and Relations Court is established under the Employment and Labor Relations Court Act, and it's established pursuant to Article 162(2) of the Constitution. So lodging a claim at the Employment and Labor Relations Court is not that difficult, and the cost of doing the same is not punitive. In fact, it is the cheapest court, if I may say, with the understanding that employees, whenever you are terminated, you do not stand at a stronger position to claim or to fight for your right. So with that understanding, the court fee for lodging claims there is pretty pretty cheap. Yes, so the beginning point, the starting point in lodging a claim in the Employment and Labor Relations Court is through something that we call the Memorandum of Claim. Yeah, you would lodge a Memorandum of Claim, and unlike in the other courts, after the pretrial, you're pretty sure that it's going to the hearing. So it doesn't usually take much of the time as compared to other matters. Of course, there are lawyers who would prefer to put in a few applications here and there to frustrate, but they're the easiest matters, if I may say so.
Okay. And now there's a matter I was talking about now, that chief magistrates can listen to employment matters. Maybe you could now also talk about that.
Well, the Chief Justice in 2018, around July of 2018, issued a gazette notice to the effect that the Chief Magistrate Court would now have the jurisdiction to hear matters where the subject matter is a salary below 80,000 and below. So that might have been done with the persuasion that it would ease the backlog in courts. But I have my reservations with regards to whether it is the best idea that the Chief Justice might have thought of with regards to solving that problem. Because there are a number of absurdities that we've noticed as employment lawyers. There are a number of absurdities with regard to some of the awards and even judgments that are delivered in the lower courts. With due respect to our magistrates, but you do realize that there are some magistrates who do not have the background of employment law. So when such matters are brought before them, you're likely to have a problem. I would not want to mention any magistrate in particular, but there are cases that we've had where a magistrate would give an award in a claim that actually the claimant did not seek for. Giving an award that was never sought for.
You have to seek it in the prayers.
In the prayers. For instance, if an employee has lodged a claim for unfair termination, that is quite different from a claim of constructive termination or redundancy. So if an employee is lodging a claim for redundancy, the specific remedies that they can seek under Section 40 of the Employment Act.
Yeah, for sure. And now, as we're talking about damages, there's the Lilian Omolo case. So maybe you could now tell us on how courts are thinking about this issue of awarding damages to those who seek relief from the courts.
Well, even before I delve into that, on the question that you just asked previously, you would find that if a judge, a magistrate, for instance, awards in a claim for unfair termination or constructive termination, awards severance pay, for instance, automatically you'll realize that that is a bad judgment in itself, because that kind of remedy is not available for unfair termination or for constructive termination. So that is normally available for redundancy. So those are some of the absurdities that are coming out of the judgments that are delivered in the lower courts. So I would recommend, for instance, I would have recommended that probably would have come up with tribunals as opposed to giving jurisdiction to these lower courts. Yes. With regards to the Lilian Omolo case, I think there are several factors that played part to the judge's decision. I can only speculate that probably he might have considered might have had a balance between the public interest and the interest of this particular individual, because you realize that she was coming from a background of having been suspended for a malpractice, and the anti-corruption court itself had made a determination on the same. So it would have been an absurdity on the part of the judge to reward her for having participated in a malpractice.
For for sure.
Yeah.
And now, as a practitioner, what are the certain types of maybe cases or issues that you have handled as an employment and labor practitioner?
I'm not very old into the into practice, but within the short time that I've practiced, I've had quite challenging matters, especially with regards to redundancies.
Okay.
Yeah, this really came up during the COVID period. Yeah, you'd find some employers, a subsidiary of a company, of a foreign company that is based maybe in South Africa, that is not doing so well here. They use proxies to employ people. So sometimes it becomes a bit challenging as to identify who in particular to sue. So those are some of the challenges that I've had to deal with regards to employment matters when I'm helping my clients.
And now we could talk about now the effects of COVID-19 and employment law, and now in general the employment sphere. We've seen, as you've said, many redundancies, people lose their jobs. So what have you observed during this season?
Well, the number of claims lodged at the Employment and Labor Relations Court registry tells it all. It has really placed a strain on the relationship between employees and employers. Because it was not something that was anticipated, that you should now probably try to blame the employers or employees. But again, we have the laws to follow. You're not going to ask an employee to leave employment without notice. The law requires you to give notice. And there are procedures to be followed when you're laying off employees. For instance, you have to identify the employees that you want to render redundant. You have to give them notices. You have to give a notice to the labor office, and all this take time. Coronavirus did not give people time to prepare.
For sure.
So definitely it was a strain. A number of employers flouted the laws, and that explains why we have a number of claims at the Employment and Labor Relations Court registry.
Okay. Now, is it okay for the employers who flouted the laws? Is it that they knew the law and actually disregarded it? What have you noticed about this situation?
There are emerging issues with regards to how such situations should be handled. The employers who had resorted to other avenues such as separation by mutual consent. Separation by mutual consent is a modern way of handling things, that you just get into an agreement with your employee and tells them that, you see, this is what is happening, but this is what we are offering you. Please sign this so that you don't lodge a claim against us. Our laws do not provide for that, but it's a practice that is being done out there. So that is happening. With regards to redundancy, it's a bit of a challenge, especially for small businesses or small size employers, because in the end it's very expensive. Where you have to follow all those procedures, paying redundancy payments, making the redundancy payments, and all that. It's very challenging. But there's a requirement under the redundancy procedures that position has to disappear. With corona with us, you would not know at what point would things improve. So asking employees to go on leave indefinitely is also not a good practice as well. It would still open you up to litigation.
There's also the issue of unpaid leave, and of course, as you're saying, redundancies. And now I would like us to talk more about now in the legal sphere. I mean, okay, we are lawyers, we protect the rights of others, but do you think law firms really abide by employment laws?
I would say that lawyers are the worst employers. Lawyers are the worst employers. We do not follow the procedures in terminating or even in hiring
Yeah, because
we
people
do
don't
not
even
pay
have
attention.
contracts.
They don't issue contract to our fellow lawyers, and even when they leave, they're no good. They don't give good packages to employees. As probably a few Ivy League law firms would do that, but a majority of our law firms, being private businesses, they don't do that. But they are very bad employers, if I may put it that way.
Yeah, for sure, because I think now the law is meant to protect everyone, right? And also, as lawyers who practice, we are also subject to the law.
Yeah, but the truth is, much as you'd want to protect lawyers against these unfair labor practices, most lawyers find it very difficult to lodge a claim or even to sue a rogue employer, who is also another senior lawyer, for instance. Yeah, so the reason being that you fear being victimized, probably they would say this guy was just incompetent and all that.
Yeah.
So most people would prefer going in silence. Yeah, so that's what happens.
Okay. And we will discuss in other forums how to improve that especially for those coming into the profession, right?
For sure, and I think LSK should take up that in future. We could have something like what the doctors have. Doctors are paid during their internships.
Yeah,
They're paid a lot of money, but lawyers are never paid. Probably we could work with something like incentives.
Yeah,
for those who take up pupils, probably they should be given incentives such as free CPDs and all that.
Yeah, for sure. Now maybe we could talk about the Employment Act Amendment Bill of 2019. What are its futures? What does it hope to enrich the current employment laws?
There are three things that I've picked out of the Employment Act Amendment Bill of 2019. And this with regard with the three sections. Number one being Section 2, which actually defines who an employee is. It has left out the indentured learners and apprentices. Yeah, they're no longer covered under that proposed amendment bill. You'll also look at Section 6 that required every employer who has more than 20 employees to have a sexual policy, a sexual harassment policy document placed in a conspicuous place within the business premise. So the proposed amendment bill says that it will require employees with at least 5, employers with at least 5 employees to have their sexual harassment policy placed somewhere. So that is also good. The other thing is with an addition, Section 15A, that now requires every employer who is merging or who is acquiring another entity to at least inform employees on the same, and also to ensure that that transitional period is taken, the interest of employees is taken care of. Yeah. Because usually you find that when entities merge, there's a culture clash.
Yeah, for
and
sure.
within a short time, these entities would want to leave. There's a particular group of employees who are disadvantaged in those mergers and acquisition, and that is what this that particular section comes to cure.
That is very important, as you've said. But the laws now, of course, about apprentice, let me say, those who are in training being left out in that, I think that should not be left out, because they're also sort of giving their energy for compensation.
It's cheap labor, actually, because you find most employers would go for interns and students who are leaving school and give them work with very little pay. But now, where the law does not include these people, this category of individuals as employees, they will have a field day
For sure.
to abuse.
For sure. Now, you've mentioned one of the emerging trends, but now I would like to talk about it in a more futuristic way. Now, COVID-19 has taught us a lot of lessons, including the issue of now working at home. What are your perspectives on the future labor laws? How should it be able to adjust to emerging circumstances?
The issue with the working at home that has emerged with Corona, I think it's in sync with the current generation. Most of the Generation Y and our generation, which is the millennials, are really not interested in sitting behind a desk from morning to evening. They would rather have an optimum working hours. Maybe if it's 3 hours, you go and do your own stuff. And that is the kind of that is the place that we are heading to. But working from home, I don't see it going past Corona, because a lot of cases have been registered of mental challenges that people are getting from working in the house. So a majority of people would still prefer going to work as opposed to sitting at home or working at home.
And now there's another issue that has just come to mind, the issue of nursing mothers. Remember there was a time, I think it was last year, when one of our members of parliament, of course, wanted to nurse, and it was an issue in parliament. Do the current labor laws actually provide such a cushion for mothers, who are in employment?
Well, we haven't reached there yet, but things are improving quite well. Some of the emerging issues, if we may say, the need for training. Most employers are embracing training. In the UK, for instance, employers are required to train their senior management on things like sexual harassment and all that. So on even how you handle lactating mothers and how you handle women who are approaching menopause and experiencing various challenges, how you handle them at places of work. Those are some of the things that are now coming. But now with our economy and putting such requirements on employers would not be sustainable at this moment. But that is where we are headed. Yes.
Now also another issue I'd like you to talk about, of course the courts can redress some of these issues that arise in employment, but as a practitioner, do you sometimes recommend mediation, workplace mediation, or let's say arbitration for certain types of disputes arising in employment?
Yes, now that is the work of a lawyer. Once a client comes, you look for the easiest way to assist. Because as an employer, an employment lawyer, we are providing solutions for businesses. You are not creating more conflict. So we are not wired towards fighting. We are not wired towards fighting at all costs. We are wired towards solving the problem. So if you can solve the problem through a negotiation, if you can solve it through an out-of-court settlement, then that is the best option.
So now you could elaborate more about employment lawyers now that you've started talking about the issue of employment, because I think most people view it as a fighting arena. I'm fighting for my rights and all this. But
there are very many innovative ways through which you can help your client without necessarily creating conflict between an employer and an employee. I will give you an instant of a problem that we had solved before without mentioning the name of our client.
Of course.
You can always enter into payment plans. For instance, with regards to redundancy payments, they are normally very huge. So as not to cripple the business of an employer, you can always enter into an arrangement with the employees, do agreements, enter into a payment plan, pay them over time, and then you solve the problem. In the alternative, these employees would go to court, lodge a claim that would still come and put a dent to your business output. Because one thing employers must appreciate is that employment suits are a risk in itself.
Yeah.
Only that you don't plan for them at the beginning of the financial year of the organization. You do not plan for them. But in between they can arise. The amount of claim employees are going to ask for is not something you can probably estimate at the beginning of your financial year. So once you look at it as a risk, you look at ways of managing those risks. One of them is to avoid court cases. If there's a way you can always solve this problem without finding its way in court, solve it at that problem. But the best way is to follow procedures.
Yeah, for sure.
Yes, for instance, nothing stops an employer from terminating an employee, but follow procedures. Yeah, so that it makes it easier even for employment lawyers to go and demonstrate to court that, you see, much as this employee was terminated, we followed the procedure.
Due process.
Yeah, and I would also urge employers to embrace trainings. The employment lawyers who do trainings on various aspects of employment relations, and that has really helped mitigate risk with in relation to employment disputes.
Okay. Now, another aspect has just come to my mind about now employment. Okay, you're saying employers should avoid court cases at all costs, but now also the WIBA Act, about now employers ensuring that they meet the safety standards, because I think those are some of the issues that arise in employment, right?
Yes.
Yeah, should also employers ensure that even their workplace is conducive so that such kind of matters do not arise?
Yes, that is one way. That's one way of mitigating the risk. Ensure that your premise is secure for your employees, and that now calls to developing proper policies. Yes. So if you have proper policies, for instance, you have management of your resources within your workplace, so you avoid accidents. So that's the least I might say about that.
So maybe now you could give your parting shot about the employment arena, let me say, in Kenya.
It's an emerging area. It hasn't picked up like other areas, but it's an area that is interesting that most lawyers should also think about venturing into. But so far, I think we have good judges who have an appreciation of employment matters and disputes, and that is a plus to the development of jurisprudence with regards to employment claims.
So it was a pleasure having you, Oscar. I'm glad we've been able to enlighten people more about employment issues, and for sure now, at least now that you said you're practicing there, I know people might look for you in case, matters are still arising, of course. COVID is not yet over. Yes, and I'm glad you found time. Thank you.
Welcome.
Thank you so much.
Thank you very much for inviting me.